Hello, everyone. Stephen Long here, the notorious BIC broker in charge, Keller Williams Realty Elite in Winston-Salem. I want to take a moment here to review with you the offer to purchase and contract, a new one, Form 2T. We have previously gone over the buyer agency agreement. We have also gone over the listing agreement. Now we will go over the ever important offer to purchase and contract. So without any further ado, let's jump right into page 1. So remember, this offer to purchase and contract is between the buyer and the seller. It has not got anything to do with the real estate brokers, the firms, the commission, none of that. This is a binding contract between buyer and seller. Real estate brokers and firms could go away, and buyer and seller are still bound to this contract. So we need to make sure we get this right, because this is on behalf of our fiduciary, whether you're on the buy side or the sell side. So starting with paragraph 1, we're going to start with some terms and definitions. We're going to define the seller and buyer. As always, be sure you get the correct legal names of buyers and sellers. If they are entities, LLCs, etc., make sure you name those correctly. If it is a husband, wife, spouses, whatever the case may be, get that correct. If it is 2 to 3 or 4 tenants or joint tenants or owners, make sure you get them named on here as well. Use their legal name. Absolutely be as accurate there as possible. And subsequently, the description of the property should also be as accurate as possible. So there is a box here now that says the property will or will not include a mobile. And so that's an interesting provision. And there actually is a mobile home provision down in the additional provisions addendum that would also be good to attach to this offer, dealing with the VIN number and whether it's real property, personal property. So if you're getting into the mobile home world, you will want to check that it will include a mobile home, and then also add the additional provisions addendum. We're also going to include the street address. Make sure you put it in as commonly as possible. Also note that there are times where the government authority, meaning the taxes, zoning, school districts, mailings, 911, the addresses may be a little bit different than the actual maybe physical address. So sometimes the tax card might be different than the physical address, which is why we want to be very descriptive in the legal description section, where we are going to try to reference as accurately as possible the lot, block, subdivision, plat book, page, the PIN number, and of course use that other description line as much as you want to. 5 acres and a house at the corner of Oak and Maple, whatever you want to put there, just feel free to use that, as well as your deed book and page. And do pull the deed book and page. Don't go off just the MLS representation. Sometimes agents put that in there and they might put the plat book or the wrong deed book and page. Pull that deed when you're doing the offer to purchase. Make sure that it's talking about the property that you're filling the contract out for, so that we don't have any ambiguity as to what property we're trying to purchase. The first line obviously is the purchase price. This is the amount that the buyer is offering. And then the second line is the due diligence. These things are familiar. You now have the option to choose how the due diligence will be delivered: cash, personal check, official bank check, wire transfer, or electronic transfer. If it is going to be electronic transfer, you can just specify what service. So if in the event you were going to put PayPal, Venmo, whatever service might actually be providing that electronic transfer, you would name it there. Again, this is going from buyer to seller. It is the due diligence due from the buyer to the seller, non-refundable, which we'll talk about. There's also initial earnest money deposit, which has the same options: cash, personal check, official bank check, wire transfer, or electronic transfer. If you're going to do additional earnest money, you'll see those options as well as there. If you're going to do a loan assumption, check that out, but also use the loan assumption addendum. Same with seller financing and the builder deposit. Look at the respective addenda that are referenced on those lines if you decide to use those. Otherwise, the balance here will be the purchase price less the due diligence and earnest money. Moving on to page 2, remember, if it is in a box, it is important. So remember, the parties agree that the buyer will pay any fee or deposit described above by electronic transfer, and the seller agrees to cooperate in effecting such transfer, including the establishment of any necessary account and providing any necessary information to the buyer provided. However, buyers shall be responsible for any additional costs if associated with the transfer. So if there is, for example, a $2, $3 fee, then the buyer would be responsible for any of the fees associated with transferring that money electronically. So that's an important thing to distinguish. It also goes on to say that if the buyer should fail to deliver the due diligence or earnest money, it would constitute a breach by the buyer, and the seller can give them 24 hours written notice to deliver good funds. And if that does not happen, the seller has the right to unilaterally terminate, and then they would be due the earnest money and the due diligence as remedy for breach of contract. So if you're in the situation working with a buyer and you are going to put due diligence and earnest money on the line and your offer gets accepted, be prepared to have it delivered, because if they do not deliver it timely as of the effective date or within 5 days, if you mark above, then they could find themselves in breach of contract, and that can cause them to be liable for the due diligence and earnest money, even though they didn't move forward with the contract. So make sure you have those conversations with your clients. When we get the green light that we're under contract, have your money ready to go. The earnest money deposit is going to be held in escrow, and we will identify that on the offer to purchase under paragraph F, where we will insert the escrow agent. This could be the listing firm, this could be the closing attorney. This just has to be someone with a trust account. An escrow account is where this money goes. Other people's money has to be safeguarded in a trust account, meaning it has to be kept saved under the guidelines of the trust account in North Carolina. So you want to make sure that that is where, and we identify where that is going. And if we change that, we have to also identify that, which you can use an agreement to amend contract, or you can do a strike through an initial, but just make sure everyone knows where that earnest money is being held. And the next blue box, it does just show that if there is a dispute over earnest money in escrow, it will be held in the escrow until it is resolved. And so if it cannot be resolved, then it will be released to the clerk of court. And because this is a contract between the buyer and seller, they would each have to get their respective attorneys to figure out how to resolve that dispute. They also agree that the real estate brokerage firm is acting, if they're acting as an escrow account, may place it into an interest-bearing trust account if we so choose, so they can do that. The effective date is the day this becomes a contract. Due diligence is the time in which the buyer is given per the due diligence fee, if any, to conduct any and all due diligence. Now we get to the date, which is here, and that due diligence date is the time being of the essence that they have to conduct any and all inspections and to be able to terminate within that due diligence period without penalty of losing their earnest money. Obviously, the due diligence fee is non-refundable, but if they should terminate beyond the due diligence date at 5 o'clock, then the seller would be entitled to retain the earnest money in addition to the due diligence fee. So that is an explanation of due diligence. There's also a Q&A on due diligence in the Real Estate Commission's website that I would suggest you guys provide if you're struggling with explaining how due diligence works, especially if it's somebody coming from out of state where they're not familiar with our process. Settlement and closing are two different things. Settlement is when everyone will come to close. So we're going to fill out the settlement date. This is the ideal, what I call a target close date, meaning this is when we want it to happen. Please make sure buyer and seller understand this is not a time is of the essence. This is a target. This is our goal. Please have a backup. It might happen this day. It might happen the day before. It might happen the day after. If it's on a Friday, it might not happen until Monday. So we need to be prepared to have a backup plan. Please do not call me and tell me your moving truck is sitting in the driveway and you have to move today and closing has been delayed. So make sure you fill this in and go over the expectations with the buyer and the seller that this is our target date for settlement, meaning the day that everyone comes to sign. Closing is the time that the recordation of the deed has happened and we can have disbursement of funds, meaning the seller can get proceeds, that firms can get commissions, buyers can get keys, all those things happen, but not until we are closed and on record. So please have that conversation and explain the difference. Again, in the big red box, it says under North Carolina State Bar has determined that performance of most acts in conjunction with a closing need a real estate attorney. So you'll hear some people say, I need a title company, or we're closing with a title firm, or da 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 da. And that can happen, but ultimately at the end of the day, an attorney has to be involved somewhere. So sometimes there are title companies that will close it, but they're just taking it back to an attorney who ultimately has to close it because the title company cannot answer any questions or advise as an attorney should be able to do. Any special assessments, as we've talked about, are going to be the responsibility of the seller. The buyer and seller's respective responsibilities for the payment of the special assessments are addressed further down. Fixtures and exclusions we went over in the listing agreement. Again, still worthy of going over with your offer to purchase, making sure that they understand anything bolted, screwed, glued, or attached or part of the property will remain unless otherwise indicated in this contract. If there is anything in question about whether it stays, put it in this contract. If your buyer is really excited about something staying, or they really like that, and you're not sure, put it in the contract just to be sure, because if it's not in this contract, it does not exist. Here's a bullet point of some of the fixtures. And again, you'll notice from the previous video with the listing agreement, things like the thermostats, all bathroom mirrors, the curtain rods, but not the curtains. So there's a lot of different things that are considered fixtures, but if it is bolted, buried, right? If it's in the ground, plants, I can count can't count the number of times the hydrangeas or the plants or something had sentimental value, and we want to dig those up. Make sure you're dealing with storage buildings. It does stay storage building and shed does stay, but just in case, if there's any question, if it's that Rubbermaid plastic storage shed and you think it stays, then make sure you get it on the contract. It goes on to say that you need to unpair any smart devices as a part of your seller's obligations and moving out. So if there's any smart appliances, smart thermostats, security systems, all those things need to be unpaired at the time of possession. Also, remember, if there's anything in the fixtures that we need to exempt or have a conversation about, this is where we're going to do it. Items that are leased and not owned, for example, satellite dishes, fuel tanks, security systems. These are items that we cannot necessarily convey because they're leased, but the buyer will want to do their own due diligence about picking up that lease if they should continue to use it, or know that the leaseholder may come and take those items away. Other items that do not convey. So these are things that are fixtures that would not convey. So inevitably, it's something like the chandelier in the dining room will not convey. The seller is responsible for repairing any issues that arise from that removal. So then if they remove the chandelier, they would have to put back a light fixture in its place. In the event that that is the case, I always encourage the seller to please remove it before we go onto the market and clearly identify what will be replaced put back in its place if need be at this time, because we don't want any hiccups at the walkthrough. It has this gaudy, ugly light fixture in the dining room instead of the beautiful chandelier. So have these conversations, be descriptive here. Don't be afraid to be very specific. In paragraph 3, we're talking about personal property. These are items that will be left and included at the sale of the real property at no value. This could be a refrigerator, it could be couch, could be anything that's not bolted, screwed, or glued. Could be playground equipment, trampolines, anything, boats in some cases. Just as the box says here, be very careful because the lender is not going to be excited about having a lot of personal property on this contract. So if there's a lender involved, you want to make sure that that is addressed here because they may want you to do that outside of this transaction, meaning get a personal bill of sale for personal items. Under paragraph 4, it talks very importantly and explicitly about the buyer's due diligence process. Remember, the buyer is strongly encouraged to conduct due diligence during the due diligence period. So they need to do any and all inspections that they feel they need to do to make sure that they are ready to move forward with this contract. That includes their appraisal, that includes a survey, that includes title search, that includes any and everything that they feel comfortable that they need to do, whether they have high-speed internet, whether they've got power, whatever they need, whether the property's on sewer or septic, whatever they feel they need to do needs to be done during the due diligence period. The seller is not obligated to ever grant an extension, no matter what. It doesn't matter if your appraiser can't get there for 3 weeks and you have a 2-week due diligence period, the seller is not obligated to extend it. So please have this conversation and buy yourself the appropriate amount of time to get that due diligence done. Also note that at the buyer's expense, the buyer shall be entitled to pursue any loan issues. And it goes on the next box to say this offer is not contingent upon a loan at all. There is no loan contingency. The buyer and seller are under contract for the buyer to provide the purchase price as agreed upon in the funds in which they attempt to earn, the way in which they disclose that they will, which we'll get to in a minute. But ultimately, it doesn't matter how they pay for it. They're just obligated to pay for it. And so there is no loan contingency. It doesn't matter if it doesn't appraise. It doesn't matter if it's got FHA issues. It doesn't matter. It is ultimately the buyer's responsibility to provide the purchase price as agreed. There is no loan contingency. So make sure you have everything to do with the loan satisfied during your due diligence period as well, if we feel that might be an issue. Now, they do have the, of course, obvious thing in due diligence, which is all the property investigations. And then it goes on to list some of the things that you will want to go over with them in an itemized fashion, including the home inspection, your document review, HOA, restrictive covenants, insurance, appraisals, zoning and planning and zoning, any kind of flood hazard, utility access, streets, public, private, all these things, special assessments. If there's a lease in the existing property, if there's any repair improvements or negotiations that need to be made, just remember the property is being sold as is. The seller doesn't have to do anything. This is where it says it right there, bold capital letters, as is in its current condition. So no seller ever has to do any repair or any fix or anything unless it is a violation or breach of the contract. So just keep that in mind. There is never an obligation for them to negotiate any repairs. If you are asking for repairs, it is simply that, and a request for repairs, which is why it's called a due diligence repair request, not demand, not a have to, request. Ask nicely. So the buyer is also advised to make any repair or improvement requests in sufficient amount of time to have this conversation prior to the expiration of due diligence. Don't send over a due diligence repair request at 5 o'clock on the due diligence date and expect them to answer, because they have no obligation to answer you, nor do they have an obligation to repair it. So give plenty of time. There should never be any kind of rush on these negotiations if possible. The buyer is obligated to repair any damage that they do in conjunction with their inspections, unless there is something that already pre-existing with the property. So for example, in a home inspection, if they're poking and prodding and looking for rotted wood, if they poke a hole in the drywall, they would be required to repair it. If they're poking into the timbers and the timber is already rot and their screwdriver goes through the rotten wood, they wouldn't be expected to repair the wood that was already rotten. There is an indemnity that basically says that you're going to hold the agents harmless and the inspectors harmless in any damage claims arising out of pre-existing conditions. The buyer does have the right to terminate at any point in time. That is a very important distinguishing point. The buyer can terminate at any point. The only question is to whether they are entitled to a refund of their earnest money or not. Because if they terminate prior to the due diligence period, they will only lose their due diligence money. If they terminate beyond the due diligence period, they will lose their earnest money, and that shall go to the seller. Closing does constitute acceptance. Please circle and underline. I wish they put this in a box. Closing constitutes acceptance of the property in its then existing condition unless other provisions are made in writing. Meaning if there's something to be repaired or done after closing, you're going to need to get something else in writing, another addendum, another agreement drafted by an attorney that says after closing something will be done, because once you close, closing constitutes acceptance. Under paragraph 5, the buyer is going to provide some representations. These are not binding contract terms. So they're going to determine whether they want to pay cash or if they're going to get a loan. And notice in the box, 5, it's in a box, it's important. If the buyer does not intend to obtain a new loan and or funds from sources other than the buyer's own assets, the seller is advised prior to signing this offer to obtain documentation from the buyer which demonstrates the buyer will be able to close on the property without the necessity of obtaining a loan or funds from the sources other than the buyer's own assets, meaning get proof of funds. So if they're planning to pay cash and they're representing they're paying cash, you shouldn't probably take their word for it. You should make sure they have the assets of the cash to pay for that. Likewise, they're going to disclose how they intend to purchase this property. Ultimately, it is not a binding term. They will, in fact, want to make sure that they are trying to get this. And it goes on to say that in this box, the obligations under this contract are not conditioned upon obtaining any loan or funds from the sources other than the buyer's own assets. Some mortgage loan programs and other programs providing funds for the purchase of the property selected by the buyer may impose repair obligations and or additional conditions or costs upon the seller or the buyer, and more information may be needed. Material changes with respect to the funding, the purchase of this property that affect the terms of the contract are material facts that must be disclosed. So the changing of things are material facts. So if you switch from cash to FHA, that's certainly a material fact that must be disclosed. Ultimately, if the buyer can still meet their obligations to pay what they intended to pay for it, then they can still go on and close. The seller may not be obligated to sign any additional documentation like the FHA addendum after we're under contract. Other property, if the buyer is in fact going to have to sell another property before they buy, you would indicate that here. You would choose they do or do not. And if they do, you would fill out the following information about that. And note, this is not a condition of the contract. It is just a disclosure as to whether they have to sell or not. There is no contingency upon it being another property being sold, which is another thing to consider when negotiating your due diligence period. If in fact that needs to happen, you may want to buy yourself enough time during due diligence to get your house under contract and or sold before you fall out of due diligence with this contract, to be sure, because it is not a contingency. I just want to make sure that's very clear. Making sure that the property disclosures are filled out, you're going to disclose that they either have or have not received them, or that they're exempt with both mineral oil and gas rights, as well as the RPOs. Again, in another box, the parties are advised to consult with an attorney prior to signing this contract if severance of mineral oil or gas rights has occurred. So if that is the case, make sure you have them run that by an attorney for advice. Paragraph 6 goes on with the buyer's obligations to address things like the responsibility for special assessments. If there's any pending special assessments, the buyer will take the title subject to those special assessments being approved. They're also responsible for certain costs that below, including anything with the loan, the contract, the appraisal, the title search, and any fees for the closing, the recording, and the deed, and preparation of those things. So make sure you have the conversation that there are going to be additional closing costs for the buyer. Authorization to disclose information is there so that we can share the information for the buyer to be contacted by the attorney, for the attorney to contact the seller's lender, the buyer's lender, and so all the parties can essentially communicate. It does not give obligation to share confidential terms. It is just so that they can get the information they need to make that closing happen. Under paragraph 7, we dive into the seller's representations. The seller is going to represent whether or not they own the property for 1 year or more, or do not yet own the property. Likewise, whether the house was built prior to 78, and there is in fact the potential for lead-based paint, and there should be that lead-based paint addendum if that is the case. Also goes over the HOA and anything that might be a part of that HOA, which the buyer should be encouraged to do their due diligence about to make sure they're not going to be in conflict or and not be able to do something that they may show desire, like put up a pool or a fence, storage building, boats, RVs, any of those things that might inhibit their use that would be in place by the regulations. Get those checked out. And here's how to contact the HOA people for that information. Fuel tanks. This is a little bit of a change. Basically, if there is any fuel tank, propane, oil, anything of the nature on site, we need to talk about that. So there either is or is not one. If there is, we need to talk about them. We're going to talk about what tank, what's it's for, what is it currently in use, is it not in use, is it owned, is it leased, is it above ground, is it below ground, what's in it, oil, propane, gas, other, possibly diesel, and the name of the vendor. Now, keep in mind, here's a big change because this is something that you'll need to educate both buyer and seller on. That the tank, if the tank is going to be included in the sale as a part of the transaction, typically it would remain. Even if it's leased, it usually remains. But the seller is allowed to use any fuel in that tank up until the time of closing. They are not now allowed to sell it. And so previously they could do that. They could sell it up until the time of closing. It was their gas. But after we go under contract, everything that's in that tank is free for the seller to use. And when we close, everything in that tank will then transfer to the buyer. So they are not allowed to sell it or otherwise liquidate it prior to closing. So very, very succinct now. Whatever's in it is what's being sold. The buyer shall be entitled to conduct any inspections to confirm the existence, type, or ownership of those fuel tanks located on the property. Likewise, the buyer should consult with the owner of any leased tanks to make sure they have that process squared away for the transfer. State law also provides that it's unlawful for any person other than the supplier of the owner of a fuel tank to disconnect, interrupt, or fill the supply tank with liquefied petroleum or LP gas without the consent of the supplier. Also, it's not safe, you will blow up. Paragraph 8, seller obligations continued about the evidence of title. They will indeed make sure they are trying to provide you clear title to the property. And it actually goes on that they will provide a general warranty deed, which we'll cover in just a moment. So there should not be any liens or anything that would prevent them providing that clear title. And this is a disclosure of them sharing their evidence of their status in doing so, which they'll sign a seller affidavit at closing. Authorization to disclose that information to from their lender and their payoffs. Also, access to the property. Note that the property has to have lawful access, and the seller has to be able to give the buyer access to it. This might be a relevant conversation to have if you have an what might be difficult seller, that they again have to provide reasonable access prior to the closing and through the time of closing to the buyer for any inspections and any of the buyer's agents or the representatives to conduct that due diligence to the satisfactory of their satisfactory. And likewise to investigate any negotiated repairs and conduct a final walkthrough inspection of the property. It says it right there. The seller is obligated to do so. Also see the warning in paragraph 4, which we'll get to in just a minute, about termination of contract following due diligence period. The seller will agree, it does agree to remove, and this is a little bit of a change, all garbage and debris as well as personal property from the premises. So it does not say clean. It does not say polished. It does not say professionally, carpets cleaned, any of that, broom swept, nothing. It just essentially states they will remove all garbage and debris. So if you have expectations of the property being cleaned in some shape or form, you may want to include that into the contract additionally. Like, for example, carpet cleaning. There is an affidavit and indemnification agreement that they will sign saying that basically when they close on the property, they're going to indicate that there's nothing there that would cause harm to the future buyers. Designation of a lien agent, if that's necessary, you would go over that. It's typically not, but there are situations where you may have to have a lien agent in estates and things like that. There has to be, and the seller is representing that they will provide good title and legal access. So general warranty deed, unless otherwise specified, This is why we also pull the deed to make sure it is in general warranty deed. There's not going to be any change from general warranty to special warranty, trustees deed, etc. If there's anything other than a general warranty deed, we may need to consult with an attorney and modify this paragraph. Likewise, the property must have legal access to a public right of way, meaning it cannot be landlocked. So that is a seller obligation as a part of this contract as well. Buyer's failure to conduct a survey or examine the title of the property prior to expiration of due diligence does not relieve the seller from still having to provide clear title. If this is a short sale, you're going to want the short sale addendum and probably need some additional education and take some classes on that. The deed is to be made to, and this is where you will put the people that you want the deed to be made to. Interestingly enough, the deed can be made to whomever the buyer chooses. It does not have to be the buyer. Mom could be buying it for their son and or daughter, and they could have it made to them. So the deed, as long as the lender is okay with it, can be made to whomever we need it to be made to. If the seller is agreeing to pay any of the buyer's expenses, we will indicate that here. So if there's going to be any of the buyer's closing costs paid by the seller, we would put that here. Make sure the seller understands this is in addition to their own closing costs and commission, because they're already going to be paying commission. Probably they're already going to have their own closing costs. This is in addition to those. This is what they would be paying on behalf of the buyer. Now keep in mind, if they're doing something like an FHA or VA loan, they will need that addendum, which states that there are certain things that the buyer cannot pay for. And so we need to have conversations of that. Typically, things like the septic inspection or a termite inspection cannot be paid for by the buyer. It can be paid by anybody else, lender, brokers, seller, anybody, but it often cannot be paid by the buyer. So make sure we have that amount. I usually recommend, if you're working with the buyer, to contact the lender and say, what amount of closing costs should we request, so that we are in compliant, because some loans have limits on the amount of closing costs that the seller can contribute. And we don't want to leave money on the table and ask for more money in this department than we can actually receive. There are owners associations fees and charges on occasion. And so that it addresses who will pay what in association or in procurement of that information. The seller pays their portions and does anything that they need in order to get it listed. Anything the buyer needs for their loan or otherwise would be the responsibility of the buyer. We talked about special assessments. There's the late listings with taxes that may be collected or paid for by at the time of closing. If there's any negotiated repairs, again, they should be made in a good workmanlike manner, and the buyer should verify this prior to closing. So if there are any negotiations or repairs, because if you're not satisfied with that repair, if it was not done in a good workmanlike manner, we're going to have some remedies on that, which I'll address in a minute. If there is a home warranty, you would check either no home warranty, or yes, the buyer is getting one, or yes, the seller is getting one, and there's the cost and from whom. Again, home warranties typically have limitations, so make sure you defer your respective clients to the home warranty companies for those. Paragraph 9, charges by the HOA, the seller shall pay these, the buyer shall pay these. Make sure you go over that with your respective client. Paragraph 10 talks about prorations and adjustments, where everything is prorated, including taxes on real property, personal property, rents, and HOA dues should all be prorated through settlement. In paragraph 11, we're talking about condition of the property. This one is important. So the condition of the property should be delivered in the same or better condition as it was at the time of contract. If that is not the case, then there is going to be some options. So, and this is a new change. And it says right here, if the property is not substantially the same or better condition at closing as of the date of this offer, the reasonable wear and tear expected, buyer may terminate this contract by written notice delivered to the seller, and the due diligence fee and earnest money deposit shall be refunded to the buyer. If the property is not in such condition, the buyer does not elect to terminate the contract, the buyer shall be entitled to receive, in addition to the property, any proceeds of the insurance claim filed by the seller on account of any damage or destruction of the property. So for example, after some of the storms that we've had this summer come through and a tree falls on the house or hits the house the day before closing, if the buyer goes ahead and closes on it, they could be entitled to the seller's insurance for those repairs. I would have very firm and detailed conversations about that to be sure that the insurance company is okay to make that happen and in the timeline that everyone wants it to happen. Likewise, it goes along with the risk of loss, saying that anything, if the loss of fire or otherwise, the buyer actually has the option of receiving insurance money if it is destroyed or terminating. Also, the seller is advised to not cancel any existing insurance until we are recorded, not till we're closed, not till we've signed everything on a Friday, but until we are on record and closed and disbursement has happened. So once the deed has been recorded, that is the time for the seller to cancel their insurance and not before. Under paragraph 12, this is an important delay paragraph. Now there are 7 days. It is a 7-day delay in the event that either party cannot close on time. There are 7 calendar days from the specified settlement date above that the delaying party can work in good faith to remedy the delay and not be in breach of contract. Once we go beyond that 7 days, the delaying party would be in breach, and the seller or the non-delaying party may, and I'll specify may, right there, terminate this contract. There's a lot of misconception that after day 7 we're dead, the contract is over. No, the contract is still the contract until one of the parties has either terminated or we have closed. So in the event that there is a delaying party, they have 7 days to cure their delay. If they cannot, then on the 7th day, the non-delaying party has the ability to unilaterally terminate the contract and move forward. So making sure that you understand that delay is very important. It is not an automatic. If neither party terminates, we can go day 10, day 12, day 14, and still have a contract. So neither party has terminated, but they could beyond the 7-day. On paragraph 13, we're talking about possession, and possession is not going to be given preferably until we are closed, but there are sometimes a buyer or seller possession before or after closing, respectively, as needed. If you're going to do that, also consider the additional provisions addendum or the vacation rental addendum if it is appropriate. Under paragraph 14, we have our pre-populated addenda, which you should be familiar with, and I would check any and all that apply, including the additional provisions, additional signatures. We got a lot of sellers, backup contract, FHA, lead-based paint, loan assumption, new construction, HOA, seller financing, short sale, vacation, or you may have something unique that was drafted by an attorney, and you can attach that here. Also note that a party can in fact draft, meaning the buyer or seller, not the buyer or seller's agent, but the buyer or seller. Also note in the box that it could be a violation of law for a broker to draft anything. But buyer or seller could do it, but they should be advised that unless they are an attorney, it's probably not safe, because unless you write it bulletproof and in legal ease, it may not be enforceable. So always defer them to an attorney for anything that may be drafted above our pre-populated addenda. Paragraph 15 talks about assignments. This operative purchasing contract is not assignable without the written consent of all parties, meaning buyer and sellers all have to agree if it is being assigned, with the exception of paragraph 16, which is tax deferred exchange, otherwise referred to as a 1031, in which case the buyer can unilaterally name the 1031 company without the seller's authority. Under paragraph 17, those are the parties. These are the parties of the contractor. It is binding on their heirs as well. So should something happen to buyer or seller, this continues and perpetuates and is binding on their heirs and successors and assigns. Number 8, paragraph 18 goes on to talk about survival and as related to that. There is nothing that survives contract unless we have it drafted. This goes over the entire agreement. There's nothing else outside of this agreement, no handshakes, no hidden deals. We will conduct the transaction to the best of our ability, and then we'll make sure we have written notice as needed for any changes. And likewise, once we have this contract signed, it is an execution. Sometimes there is multiple copies of the exact same document. Paragraph 21 says that if a buyer signed a contract and a seller signed a contract, and there are 2 different pieces of paper, but they're identical, then they can be put together to constitute one instrument. So that's how that used to work. In the days of electronic signature, it's a little bit less common, but just so you know, that is into the contract. Paragraph 22 talks about the computation of days for prorations, and make sure you understand that the counting of days are usually calendar days. If there is a leap year, it does include the extra day as well. On paragraph 23, it talks about remedies in the event of a breach. And this is important because I get this question a lot. What if the buyer does this? What if the seller does this? Well, if the buyer breaches contract, then the seller has the right to keep the earnest money and keep the due diligence. That's the liquidated damages are the sole and exclusive remedy to a seller in the event of a buyer breach. So that's why we have earnest money and due diligence on the contract. Make sure that if you are on the seller side, earnest money and due diligence amounts are satisfactory to make you whole in the event that the buyer does terminate. during due diligence, after due diligence, or even the morning of closing. And they can terminate the morning of closing, and the sole and exclusive remedy to the seller will be due diligence and earnest money. Also note that if the party is seeking recovery of attorney fees in the event of a breach and where the money is not given freely, they do have to notify the party within 5 days that you have to pay me X, or I will be getting an attorney and you will pay me X with the attorney fees. So again, the prevailing party has to pay the non-prevailing party's attorney fees in most cases if the proper notice is given. Otherwise, that pretty much sums up our offer to purchase and contract, less signatures, and of course the ever-present wire fraud addendum, so please, or wire fraud disclosure. So please do not forget to go over that. Very, very important information. And then you have your notice information here. Please make sure you put notices for the buyer, seller, and their respective agents and firms as best possible. With that being said, the only thing left is your signature pages where we want to track the paper. So this is not necessarily a binding part of the contract, but just a very convenient way to track money. So if due diligence and earnest money are being given, when did it go from seller or from buyer to buyer's agent to seller to or to listing agent to seller, and tracking both those things along the way, making sure that we have the receipt and the deposit of the escrow money in the escrow account as well. So this is just to track that money. So please use and execute that as needed. With that being said, that is an abridged version of the offer to purchase and contract review. As mentioned, there is also a guidelines document in addition to what I have just provided you. That is a very good resource for you like to go over that. There's also an overview of the offer to purchase and contract that I'm going to post in the comments. That is also a cool little document if you would like to use that for going over this contract with your clients as well. So slow down, don't be me, have good conversations with your buyer and your seller, be able to explain this very succinctly, but also in great detail, because there are a lot of provisions that will affect your client. And we live in a world of click, 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 sign, and we are expected, we are lawfully obligated to go over this contract with our respective fiduciary clients. So do that and make sure you're making solid contracts so that in the event something goes awry, your client is protected and you look like a hero and not a zero for not doing good paperwork. So have a great afternoon. If you have any questions, feel free to let me know, put them in the comments, and we will keep this here for future reference. So thanks so much.